Good morning. My name is David Feigl. I'm a former FDA Division Director and Office Director in the Office of New Drugs. And I've been asked this morning to make some comments on the legal considerations on model sharing and the implications of being able to place that information in model master files. Now, master files are an interesting mechanism that FDA created at least as far back as the 1980s. And it's largely for the purpose of protecting the confidentiality of confidential information, one type of which are trade secrets. When you look at the other types of intellectual property that relate to drugs, patents, copyright, trademarks, FDA-granted exclusivity, which adds value in its own way, all of these are fairly transparent once granted. But what's unique about the information in a master file, and actually much of the information in an NDA or an ANDA or a BLA, is that the information remains confidential and known only to FDA and to the people who submitted the documents. So my focus is going to be on, can we make the case that we can protect modeling and modeling systems by declaring that they're trade secrets? Now, trade secrets are interesting. They evolved out of state common law, out of property law. Trade secrets were considered the property of the person who created it. Lately, there's more federal laws that involve trade secrets, and we'll take a look at how it's discussed in the Food, Drug, and Cosmetic Act. But let's start with sort of the most common definitions of a trade secret. It has certain characteristics. It's proprietary information that a company or an individual uses and has exclusive right to. And so first, it has to be genuine and not obvious, meaning it has to be something that's tangible, it has to be something that's created. FDA is very explicit about what kinds of things they mean by this. Second, it must provide a competitive or economic advantage and have value to the owner. And notice that's in the present tense. So something that no longer has value, no longer a trade secret. And third, it must reasonably be protected from disclosure. So if we boil it all down, it actually is all in the title. It has to be relevant to trade. It has to add value to trade. It has to be something that is commercially valuable, and it has to be a secret. We find references to trade secrets in the Food, Drug, and Cosmetic Act. In the Prohibited Acts, there's a Prohibited Act for a person who works for the FDA. To sort of shorten this long paragraph, which is even longer in the Act, any person revealing, it's a prohibited act for any person to reveal a trade secret which is entitled to protection. And there's penalties defined in the federal criminal statutes. It's a little unusual as a prohibited act. Most of the prohibited acts are things manufacturers can't do. But this is something that an FDA person, an employee or advisory committee member cannot do. The Code of Federal Regulations further kind of expands this, and we can compare this to sort of the common law definition of a trade secret. So a trade secret may consist of any commercially valuable, okay, that's the same, it's commercially valuable, so that matches, plan, formula, process, or device. So that is very specific. But I think by saying formula or process, that would include modeling, that is used in the making, preparing, compounding, or processing of trade commodities. Okay, so it's involved in preparing, making decisions about how to make a drug, so that works. And that can be said to be the end product of either innovation or substantial effort. In other words, the modeling has to be innovative and there has to be a substantial effort. That's back to the common law wording. It shouldn't be obvious. And there must be a direct relationship between the trade secret and the productive process. Is the modeling used actually in the drug approval process? I think the modeling actually fits this pretty well. And then they go on to say that data and information submitted or divulged to the FDA administration, which falls within the definition of a trade secret or other confidential information, but falls within the definition of a trade secret, are not available for public disclosure. So full stop. FDA says, you say it's a trade secret? We're not going to disclose it. So what pushes back on this? Well, another law, the Freedom of Information Act. But the Freedom of Information Act, which requires the government to actually be transparent about applications and its own documents and so forth, has two important exclusions. The one that relates to manufacturers is that it doesn't allow disclosure of trade secrets. And the one that applies to FDA is it does not allow FDA to disclose internal deliberative or in-process documents, emails, draft reviews, an internal evaluation of a master file. These would not be disclosable under FOI. There's been some interesting court cases. There was a lawsuit that made the case that when an IND has been abandoned, the information from that no longer commercially pursued product should be made available to everybody so that everybody can learn from that. But the manufacturers made the case to the court that just because that particular molecule is not proceeding doesn't mean that the information in that application are not commercially valuable. And thus, because they're still commercially valuable, even though that product will never be sold, that information is still a trade secret. The courts agreed. So the INDs and the NDAs generally are pretty safe. It's complicated because they're big documents and there's lots of information in those documents that are not trade secrets, which is why when you request an application, you can get a redacted version of it that has the non-trade secret information. When there's a request to release information, the company is actually allowed to actually identify what are the trade secrets and to say what can be disclosed and what can't. There's also an act that required federal agencies to have policies to assure the quality of public information that's disclosed, and this doesn't really have a lot of direct bearing on master files. So when we look at the methodology and the validation, where we could put methodology validation locations, what are our options? Well, the obvious two are public ones and confidential ones. And it could be in the peer-reviewed literature. There's quite a bit of methodology in the peer-reviewed literature. Some of them put appendices on the web that may have source data, that may have source code, but it's not as detailed as you'd find in a typical FDA application. There's web publishing with raw data and statistical programs. NIH has policies on release of data, raw data, and raw data sharing. But the other place, and there's a lot of methodology located here, is all of the methodology that's confidential to FDA. And when you think of all the validation and verification of methods in the production of drugs, from verification of assays to validation of statistical methods for clinical trials, there's a lot of information that is not disclosed and embedded in these. And the master files is a location where if you wanted to have a focused data set that really honed in on the issue of a modeling information, I think it would be perfectly legal to put it there and for FDA not to disclose it. So what are our issues? Well, one issue is there's an owner of the master file. So if someone wants to use it, they have to actually get the owner's permission. The owner may have complex relationships with other companies. There may be conflicts of interest. What makes the master file a trade secret? Is it a method? Is it an algorithm? Is it a unique data set? What is the trade secret? Is it software? Is it a validation data set that was used for statistical modeling that itself is public, but the software algorithms are not? And who verifies the use and validation of the information? Presumably FDA, the way it does when it evaluates other master files. How does FDA track whether it's actually evaluated a master file that has modeling information and considers it validated? Would it ever be publicly available in an FDA review? The FDA own modelers are actually fairly good at publishing their modeling results and the thoughts on methodology. Does the master file block that in some ways? What exactly are the boundaries of the trade secret? So, in conclusion, the whole purpose of master files is to store secrets. It could do that very well. And part of what's necessary for FDA to think through is what is it that they think would be best kept in a confidential manner. It wouldn't be as transparent as public domain information, but it could reduce redundant validation work, and it would provide far more detail than the published literature. Thank you very much.